Hi, I'm Todd Lard, a salt partner at Eversheds Sutherland.
And I'm Jessie Eisenmenger, a salt associate at Eversheds Sutherland.
We're going to spend a few minutes today talking about a recent United States Supreme Court decision that affects the collection of sales tax. 50 years ago, the United States Supreme Court interpreted the Constitution to require a bright line physical presence of a remote retailer before they have to collect sales and use tax in a certain jurisdiction. States have long opposed that approach and have thought that perhaps, especially in the era of electronic commerce, that perhaps the physical presence standard shouldn't be applied. So we've seen a lot of efforts over the years to try to undo the physical presence standard, and in 2016 we saw one state step up, South Dakota, and really put a lot of pressure on that standard.
Right, so in 2016, South Dakota passed a law requiring remote sellers with greater than $100,000 in gross revenue annually from the state or 200 separate transactions sold into the state to collect and remit sales tax.
So South Dakota has been participating in the Streamlined Sales Tax project for a number of years and really felt that their sales tax collection had been simplified enough that it was time to change the physical presence standard. So they applied this new standard to for taxpayers and then began to try to make them collect sales tax. Ultimately, the case went to the United States Supreme Court, and in June, the court agreed with South Dakota and in fact said that the physical presence standard was not the appropriate rule anymore. So we got that from the court, but what we didn't get from the court is what exactly the new standard is. We got some hints. I mean, the court liked that South Dakota had been a member of Streamline, had simplified. They liked the fact that they had a threshold that you had to have a certain number of sales or a certain dollar number of sales in a jurisdiction before you had to collect. And lastly, it was prospective only. There was no retroactivity. So the court liked that, but we don't know exactly how it all fits together. So now what we've seen is a lot of states trying to react to that to figure out how they can apply this new standard to their sales tax collection.
Right, so we've seen states take three different approaches towards applying the new standard for sales tax collection. The first approach are states that have adopted the South Dakota thresholds exactly, the $100,000 in gross revenue and 200 separate transactions. Among those states, though, we do see some potential issues. Some of the states who have adopted the same thresholds are not members of the Streamlined Sales and Use Tax Agreement. So some of those might not have the necessary simplification in their code, even with the South Dakota threshold, for that to pass constitutional muster. We also see some of those states potentially applying their new laws retroactively, which again is not like the Wayfair case. Our second group of states are ones that have applied a threshold, but it's not the same threshold as South Dakota, so that might be a dollar threshold that's higher, but no separate transaction threshold, a lower dollar threshold, or no separate transaction threshold. And finally, we have some states that currently had laws on the books saying that they could assert nexus to the full extent of the Constitution. And so with this change in the constitutional interpretation, those states are beginning to adopt South Dakota-like thresholds by regulation rather than by legislation.
And this is a quickly evolving area. The decision just came out in June, and a lot of large retailers started complying almost immediately. But medium-sized, small sellers, I think they're still trying to figure this out. And of course, the state are still trying to offer guidance. And as we approach the holiday shopping season, I think we'll see a lot more guidance, a lot more pressure on this issue.
So thanks for joining us. For more information on recent developments in state and local tax and other bottom line videos, please access eversheds-sutherland.com.